Hello everyone, my name is Renato Costa, this is Aussie Law, and today we will talk about a case called PAPE and the Federal Commissioner of Taxation from 2009. This case brings together two things that we have already talked about: the nationhood executive powers and how the government can expend money. Before talking about the facts of the case, there are three things that I want you to remember. One, that sections 81 and 83 of the Australian Constitution say that the executive can appropriate money from the Consolidated Revenue Fund via an appropriation bill in Parliament, and that they have to do it for the purposes of the Commonwealth. Two, that although appropriation is made by law and has to be authorised by Parliament, government expenditure is still not completely free. As affirmed by Justice Mason and Jacobs in the AAP case, there is a difference between appropriation and expenditure. If these two things made no sense to you, I recommend you to watch the video that is appearing in your screen. The third thing that I want you to remember is that the executive has certain powers that are not necessarily expressed in the text of the Constitution. There are certain powers that are non-statutory powers, and one of the types of non-statutory powers is called the nationhood power. If you don't know what I'm talking about, click the playlist that is appearing on the top right corner. And so you don't ever feel lost again, just make sure you subscribe to our channel and you've hit the bell sign. That way you'll be notified every time I upload a new video. Okay, let's go to the facts of PAPE. In 2008, if you remember, there was something called the global financial crisis. It started in the US, but then came crashing down all of the market economies in the world. And Australia was one of the many economies impacted by that crisis. As a response to the GFC, the Australian government decided to pass two tax bonus acts. These were part of a government fiscal stimulus package. In synthesis, that meant that taxpayers who earned less than $100,000 in the previous financial years to the crisis would be entitled to receive a payment that would range between $250 to $900. And Brian Pape was a taxpayer who was to receive $250 under this scheme. However, he challenged the payment, saying that the whole scheme was unlawful and void. According to Pape, the federal government could not spend money that way. So when the challenge ultimately came to the High Court of Australia, the question before the High Court was whether the tax bonus acts were a valid exercise of an implied or an express executive power in the Constitution. Did the government have the power to spend money in such a way? The High Court of Australia decided that it did. The majority decided against Pape's claims, and they upheld the validity of the fiscal stimulus package, and therefore they said that there was a valid appropriation and a valid expenditure of money by the Commonwealth. But why? What did the justices say in this case? First, let's start with the point that all justices agreed on. Sections 81 and 83 do not confer the power to the executive to spend money. All of the justices agreed on that. They followed the decision of Justices Mason and Jacobs in the AAP case, and here they established that the substantive power to spend the public monies of the Commonwealth is not to be found in sections 81 or 83, but elsewhere in the Constitution or statutes made under it. So, although valid government expenditure must be preceded by an appropriation, the power to expend money is not to be found in sections 81 or 83 of the Australian Constitution. This power must be located within the head of power in, for example, section 51, 52 or 122. From there, 6 of the 7 judges decided that in this case there was a valid appropriation made by law to fund the tax bonus. Justice Hayden dissented. Now to the majority judgment concerning the power to spend money via the fiscal stimulus package. Let's start with Chief Justice French. Remember Justice French from the Federal Court of Australia in the Tampa case? He is now in this case the Chief Justice of the High Court of Australia, and in his Honour's opinion will relate the nationhood powers according to the Tumper case and with the possibility of government expending money. It is true that His Honour did not expressly refer to the nationhood powers, but he made it clear that the executive power of the Commonwealth, conferred by Section 61 of the Constitution, extends to the power to expend public monies for the purposes of avoiding or mitigating the large-scale adverse effects of the circumstances affecting the national economy disclosed on the facts of this case. So although he did not say expressly the words nationhood powers, you can see that he applied the implied executive powers of Section 61 to the situation in PAPE. And Chief Justice French in this case was part of the majority, with Justices Gummel, Crennan and Bell. The Honours found that the expenditure was authorised under legislation passed pursuant to Section 5139 as an incident to the Executive's implied nationhood power in Section 61. All in all, the stimulus package was passed under the nationhood powers by reference to the national government's ability to respond to the economic crisis. In their Honour's opinion, Justice Gummel, Crennan and Bell said that determining that there is the need for an immediate fiscal stimulus to the national economy in the circumstances set out above is somewhat analogous to determining a state of emergency circumstances of a natural disaster. Justices Heen and Kiefel did agree that the nationhood powers existed, but their Honours didn't see how these implied executive powers could authorize Commonwealth to spend money in this particular situation. Justice Hayden, in dissent, did not even recognize the existence of the nationhood powers within Section 61. Justice Hayden's opinion is not unwarranted, because many scholars believe that this recognition of an implied executive power within Section 61 may have the same expensive effects as the literal interpretation of the legislative powers of the Commonwealth in Section 51. What do you think? Do you think that this can have the same effects of enlarging Commonwealth powers? Leave a comment below. So, in PAPE, the High Court of Australia decided that Sections 81 and 83 of the Australian Constitution by themselves do not authorise government expenditure. They enshrine the principle that government expenditure must be authorised by Parliament, but they do not authorise the expenditure by themselves. That the nationhood powers exist and that they can be used as a valid constitutional source for government expenditure depending on the circumstances. And that, although limited by the federal structure, these nationhood powers can be very broad. This last assumption, however, was challenged in another case. In the two Williams cases, the High Court returned to the question of government spending, but this time without taking into consideration the nationhood powers as a source for government expenditure. These two cases will be analysed in my next video, so make sure that you subscribe to our channel and that you hit the bell icon. I'll be back soon and I hope to see you around here. Until then, ciao!